All right. Court's now in session. The Honorable Roy G. Meek presiding.
You may be seated. In the case of People versus Joanne Eileen Hadley, counsel identify for the record, please.
Morning, Your
That
Honor.
was I, sir. Joanne Hadley.
Morning, Your Honor. Mark Webb on behalf of the people.
Morning, Your Honor. Karen Tomczyk on behalf of Ms. Hadley.
This was set as a final pretrial. Has there been any resolution reached?
There is not, Your Honor. As far as I know, it is continuing on towards trial.
What was the last offer in this case?
Judge, I was only able to find a PCC summary dated April 5th or 12th. And that was that offer was for guilty to OWI 3rd and a BK cap of 3 months, but I think
That's the same offer in the pretrial summary.
Okay, thank you.
Okay.
But I did see an email. I don't know if there was an exchange between Mrs. Ambrositis and Ms. Tomczyk, but I think they may still be negotiating.
It's got one count covering while intoxicated third offense, a felony, carries a maximum penalty of up to $5,000 fine, up to 5 years in prison, at least 60 days of community service, ordered in the rehabilitative programs, cost of prosecution. All right. Anything else you wish to talk about today, Ms. Tomczyk?
No, Your Honor.
All right.
I would like to speak, sir.
You probably should speak to your attorney first. though.
They don't talk to me, sir.
All right.
I passed all of my urine since March.
Okay.
I
I'm gonna
also-
stop you right here, okay?
Wrote you a letter. I am in North Lakes, counseling. I live in Holton Lake. I'm trying to save my son. My son right now is in jail. He tried to commit suicide. And this was part of it. It's been going on for a long time. I spoke to the prosecutor attorney about this.
So
I
are
went to my-
you're unsatisfied with Ms. Tomczyk's representation? Is that what you're saying?
Yes, I am, sir. I asked her
Okay.
to subpoena Patricia Caperi and she never did. She don't talk to me even before this trial.
Your Honor, Ms. Hadley has
Yes.
not called my office and asked for an appointment. She asked me to subpoena somebody to trial. We have not went to trial yet.
All right.
I'm not sure how she's saying I'm not talking to her if she's not asking for appointments to talk to me.
This is set for trial in September. I don't think we're gonna be having a trial in September anyways until we get this COVID stuff situated and we get better speakers and microphones for the courtroom.
Your Honor, I'm asking.
So what we're gonna do is I'm gonna convert September 22nd to a settlement conference date. And you'll get a new trial date, probably in October. And we'll go from there. And at this point, Ms. Hadley, I'm gonna tell you, contact her office, make an appointment, and go visit her. All right?
Your Honor, I'm on disability. I've worked all my life and I have a nerve problem. I have passed all of my urine tests.
You're
And
gonna
there's
give all
financial-
that information. The only thing that means right now that you passed all your urine tests is that you're not gonna face a motion for bond revocation where, if you didn't pass them, the prosecutor could be doing a motion to revoke your bond and throw you back in jail,
Yes, sir.
okay?
I'm asking.
So that's good in that aspect, that you're not doing that. So at this point, this is not the time for you to argue your case to the court, all right? So I'm gonna tell you to contact Ms. Tomczyk's office today, get an appointment, go see her, take all your stuff. If you're unsatisfied after that with her representation of you, and her view of the case, then write a letter to the court, and we'll set a status conference to decide whether you need another attorney. All right?
Yes, sir.
Okay? We're in recess.
All rise. All rise. 55th Circuit Court is now in session, and the Honorable Roy G. Meek presiding.
You may be seated. In the case of versus Bradley James Orr, counsel identify for the record, please.
Good morning, Your Honor. Mark Webb on behalf of the people.
May it please the court, Matthew Boucher here on behalf of Bradley Orr, who is present via Zoom, Your Honor.
You are Bradley James Orr.
Mr. Orr, you'll need to unmute your microphone, please.
And you are Bradley James Orr? We can't hear you, so. We say you've been able to talk to your client this morning?
Yes, his volume was just working.
All right. Were you planning on doing anything today?
Your Honor, we do have a resolution, and I think we're close. I've been discussing it with my client. We talked a bit more this morning to make a decision. He's just asking for a very short period. 2 weeks would be more than appropriate to discuss it a little bit more and allow him to make a decision. We do have an offer, and we have discussed it, but he'd like a little bit more time to discuss his options with me.
All right. We'll try and schedule another status conference prior to the trial date, okay? We'll send out notices when that is.
Thank you, Your Honor.
All right, you're all set.
Thank you.
Anybody in the waiting room or anything? We're in recess.
All rise. Circuit Court is now in session, and the Honorable Roy G. Meek presiding.
You may be seated. On the case of the people versus William Marion O'Connor, counsel identify for the record, please.
Good morning, Your Honor. Mark Webb on behalf of the people.
Your Honor, Austin R. Rowe on behalf of Mr. O'Connor.
All right, Mr. O'Connor has failed to appear here today. And it's not zoomed in. It's set at 10 o'clock, it's almost 10:30. This bond's gonna be canceled, the bench warrant will be issued for his arrest. Bond in the amount of $50 cash.
Your Honor, Austin R. Rowe, attorney for Mr. O'Connor. I've been trying to call him. I haven't been able to contact him at like 2 phone numbers I know of. I sent him an email. My office sent him an email on June 28th telling him today's date and time of hearing, including instructions how to appear by Zoom. Also sent, my office also sent on the 28th a letter by U.S. mail with the same information, Your Honor. I don't know where he is right now. Last time I heard, well, I don't know.
All right. The court will hold later a decision whether or not to forfeit the bond. Calling the case of the People versus Robert Gerald Aldrich Jr. Counsel identified for the record.
Good afternoon, Your Honor. Mark Webb on behalf of the people.
Your Honor, Austin R. Rowe, appearing on behalf of Mr. Aldrich.
You are Robert Gerald Aldrich Jr.?
Robert Gerald Aldrich. Yes, sir.
All right. And this is the final pretrial. Here's another pretrial offer has been prepared. Is that correct? Or just never signed before? The offer is to both counts of home invasion of third degree as habitual third, this habitual fourth, and stick to a 12-month cap at the county jail.
That's correct, Your Honor. I have one with Mrs. Schwartz's initials on it.
All right. And you discussed that with your client, Mr. Rowe?
I have, Your Honor.
And does he wish to accept it?
No,
No. All right.
he wishes to proceed to trial, Your Honor.
We have a trial date set for September 29th for a jury trial because of COVID and the way we have to space people. Court's going to cancel that trial date, but we will keep that on the time for a status conference and we'll set a new trial date later on. Anything further, Mr. Rowe?
No, Your Honor.
Anything further, Mr. Webb?
No, thank you, Your Honor.
All right. You ready to proceed on anything else, Mr. Rowe?
I don't believe so, Your Honor.
Okay. Court is in recess.
All right. All rise. 55th Circuit Court is now in session. The Honorable Roy G. Meek presiding.
May be seated.
Oh, sorry.
Calling the case, the People versus William Marion O'Connor. Counsel identified for the record.
Good morning, Your Honor. Mark Webb on behalf of the people.
Your Honor, Austin R. Rowe for Mr. O'Connor.
You are William Marion O'Connor?
Yes, Your Honor. This is William Marion O'Connor.
And how old are you?
42.
Would you raise your right hand and be sworn?
Yes, Your Honor.
Do you solemnly swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes, ma'am.
Mr. O'Connor, you've received a copy of or gone over the information with your attorney, is that correct?
Yes, Your Honor.
All right. And Mr. Rowe, does he waive reading of the information for purposes?
He does, Your Honor.
Previously, he waived preliminary examination, is that correct?
That's correct, Your Honor.
All right. Mr. O'Connor, you're being charged with count one, breaking and entering a coin-operated device. That's a felony that carries a maximum penalty of 3 years in prison or a $1,000 fine. And you're also being charged as habitual offender third offense, which means the maximum penalty could be twice that amount. So the maximum penalty is now 6 years in prison. The minimum is discretionary with the court. Do you understand the charges and the possible penalties?
Yes, Your Honor.
There's one of three possible pleas you may make to this charge. You may plead guilty if you are guilty, but don't plead guilty unless or you are guilty. You may plead not guilty. You may stand mute, or you may plead no contest, which means you will not contest the prosecutor's offer of proof and it amounts to a plea of guilty. You understand the one of 4 possible pleas you may make?
Yes, Your Honor.
Answering to count 1, breaking and entering a coin-operated device, how do you plead?
No contest.
No contest, Your Honor.
Answering to habitual offender third offense notice, how do you plead?
No contest.
Okay. Do you understand that no one may make any promises for this court as to what your sentence will be?
Yes, Your Honor.
Court further informs you that if your pleas are accepted, you will not have a trial of any kind and therefore give up the following rights. The right to have a trial by jury, the right to have a trial in front of this court sitting without a jury, the right to be presumed innocent until proven guilty, the right to be proven guilty beyond a reasonable doubt, the right to question all witnesses against you, the right to have this court order witnesses on your behalf into court to testify at trial, the right to remain silent and not have that silence used against you during trial, and the right to testify at trial if you wish to do so and have your testimony considered in the same manner as any other person's testimony. Do you understand these rights?
Yes, Your Honor.
You understand by pleading no contest, you give up each and every one of those rights.
Yes, Your Honor.
Mr. Webb, what is the plea agreement?
Your Honor, in exchange for the defendant's plea of guilty to breaking and entering a coin-operated device, count 1 and 3, as a habitual third offender, we'll dismiss the habitual fourth offender in sentencing, and there is no sentence recommendation or agreement.
Mr. Rowe, is that your full and complete understanding of the plea agreement?
It is, Your Honor.
Mr. O'Connor, did you hear it was put on the record as the plea agreement?
Yes, Your Honor.
Did you understand it?
Yes, Your Honor.
And are you in agreement with it?
Yes, Your Honor.
Has anybody promised you anything beyond what was stated in the plea agreement to induce you to plead no contest?
Not at all, Your Honor.
Does anybody threaten you or your family in order to induce you to plead no contest?
Not at all, Your Honor.
Has anybody promised you that if you pled no contest, this court would be lenient upon you in any way?
No, Your Honor.
Is it your own personal choice to plead no contest?
Yes, Your Honor.
And are you doing so freely and voluntarily?
Yes, Your Honor.
Do you have any questions about what the court has told you?
No, Your Honor.
Have you understood everything that the court has told you?
Yes, Your Honor.
In light of everything that the court has told you, do you still wish to plead no contest?
Yes, Your Honor.
All right. And the attorneys agreed the court could review a copy of the police report for a factual basis. The court has done that, found the factual basis for the plea, and you'll reduce that, Mr. Webb, to an offer of proof to be put in the file?
Yes, Your Honor.
All right. Has the court complied with the court rules, Mr. Webb?
You have.
Has the court complied with the court rules, Mr. Rowe?
It has, Your Honor, and I'd also say the reason for the no contest plea is twofold. First reason is to avoid civil liability. Second reason is Mr. O'Connor tells me that he was so drunk at the time he doesn't remember the facts at that time.
Those are acceptable reasons for a no contest plea. Court has not agreed upon the possible plea or the possible sentence with either the prosecutor or defendant or anyone acting in the interest of either. Court is convinced the plea is accurate, has been freely, voluntarily, understandably, and knowingly made. Plea is accepted in order to enter upon the records of this court. Sentencing will be set for October 25th at 10:20 a.m. Defendant is referred to the Department of Corrections for the preparation of a pre-sentence investigation report. Mr. O'Connor, the court's going to require your presence in the courtroom on that date for sentencing, okay?
Yes, Your Honor.
All right. And bond is continued. Mr. Ween, do you have any questions or information for Mr. O'Connor?
Yes, Mr. O'Connor, could you verify your address, please?
Yes, 308 4th Street, Manistee, Michigan, 49660.
Could you do the zip one more time, please?
49660, Manistee, Michigan.
Thank you. And could I get your telephone number, please?
Yes, sir. 231-655-115. And can I ask you a question real quick?
1 second, Mr. O'Connor. Could you repeat your telephone number? I didn't get the last part.
Oh, sorry. 231-655-1175.
75. Okay. Mr. O'Connor, we're going to be sending you some packets in the mail. If you could get those completed and then contact the number that's listed on the packets to set up your PSI interview, please.
Okay. And as soon as I get it in the mail, I'll get on top of it right away.
Appreciate that, sir. And you can go ahead with your question.
I heard him say October 25th for sentencing and appear in person, but did he say 10:20 in the morning?
Yes.
Okay, thank you, Your Honor.
All right.
I was just making sure, so I wrote it down correctly.
You're all set, Mr. O'Connor. Keep in touch with your
All right.
attorney when you get that PSI packet, okay?
Yes, sir. And thank you, and have a good day.
All right. We're in recess.
All right. 53rd Circuit Court is in session. Roy J. Meek presiding.
May be seated.
Judge, can we start with Mr. Archibald?
Sure. Did you need to talk to Mr. Archibald first, Mr. Rowe?
No, Your Honor, I've already talked with him. Thank
All
you.
right. Calling the case of the people versus Michael David Archibald.
Good afternoon, Your Honor. Mark Webb on behalf of the people.
Your Honor, Austin R. Rowe, talked to Mr. Archibald, and Mr. Archibald, don't mind for this time. Just come right over here.
You are Michael David Archibald?
I am.
Okay. Just set as a final pretrial. Any resolution determined in this case?
No, Your Honor, there's been some discussion, there might be further discussion, but not at this time.
All right. Set for a trial date of September 30th. We're not going to be having a trial on that date, but we're going to leave that date on as a status settlement conference. So you still have to appear on the 30th. All right. Anything further from either party?
Did you say it's September 30th?
Yeah, that's the trial date. We're just going to keep it on as a status settlement conference date.
That is it?
Have a good day.
All right, Mr. Archibald.
You all have a good day.
What do you want to do next? Mr. Davis, or what do we got in the waiting room?
I have everyone in the waiting room. I just brought in the jail. Their video's not working, but it does show the audio is on.
Okay.
Well, let's do Mr. Davis. Calling the cases of the people versus Jonathan Charles Davis.
Good afternoon, Your Honor. Mark Webb on behalf of the people.
Your Honor, Austin R. Rowe on behalf of Mr. Davis.
And you are Jonathan Charles Davis?
Yes, sir.
All right. And we're here on file 21-006602-FH for a final pretrial, and we're also here today on an arraignment for probation violations in file number 17-005497-FH. An amended bench warrant was filed today, and it now holds 9 counts on that. How do you wish to proceed today, Mr. Rowe?
Your Honor, Mr. Davis pleads not guilty. He waives the right to have a contested hearing within 10 days without waiving the right to have a contested hearing.
All right. Not guilty pleas will be entered on behalf of Mr. Davis to all the probation violation charges. And we will set up the status conference, settlement conference date as soon as we can on that case. And we will. He's also here on he failed to appear at the status conference in the other case, so bench warrant was issued there. We're just gonna enter not guilty pleas to the contempt of court charge in that case. And that case is also set for a trial date of September 29th. The court has determined we're not going to do a jury trial during September until we get some better electronic equipment for the courtroom. And we will put both cases, and we'll try to move it before the 29th. And if you want to get a day that works for your schedule, contact Ms. Ruppert about getting a date for earlier than the 29th.
Thank you, Your Honor.
You're all set, Mr. Davis, for today. On the case of the people versus Jennifer Joy Seahigh.
Good day, Your Honor. Mark Webb on behalf of the people.
Your Honor, pardon me, Your Honor, Austin R. Rowe appearing on behalf of Ms. Seahigh.
You are Jennifer Joy Seahigh?
Yes, Your Honor.
All right. This is the date for a final pre-trial in this matter. It's my understanding that the offer is still the same from the pre-trial summary done back in June. Is that correct, Mr. Webb?
It is, Your Honor.
And, that was to plead as charged. We'll count one and dismiss. I think it's only one count there anyways, and then I have an agreement for a cap at 6 months in the county jail, no more than 6 months in the county jail, but.
And we'll also dismiss the second or subsequent drug offense notice.
Okay. So it would just be possession of methamphetamine only.
Yes.
We had an opportunity to talk that over with your client, Mr. Rowe.
I have, Your Honor.
Does she wish to accept that offer?
Not at this time, Your Honor.
All right. All right. Set for a jury trial on September 30th. We're going to cancel the jury trial date for that date, but we're going to keep that on as a status conference settlement conference. And the court's going to require the defendant to be here in person on that date.
Yes, Your Honor.
All right. You're all set, Ms. Seahigh.
Thank you.
In case of People versus Kelly Joanne Beatty. Counsel identified.
Good day, Your Honor. Mark Webb on behalf of the people.
Your Honor, Austin R. Rowe appearing on behalf of Ms. Beatty.
And you are Kelly Joanne Beatty.
Yes, I am.
And today's set as a final pre-trial. And what is the current offer in this case?
Your Honor, it is the defendant can plead guilty to count one possession of methamphetamine, and I would recommend a sentence under 7411 if she's otherwise eligible.
All right. Just talk that over with your client, Mr. Rowe.
Your Honor, may I ask Mr. Webb a clarifying question about the deal?
Sure.
Is the motor vehicle operation without security to be dismissed?
Yes.
Yes, I've talked about that with my client, and she would like to accept that, Your Honor.
All right. Ms. Beatty, how old are you?
I'm 40 years old.
Would you raise your right hand and be sworn?
Do you solemnly swear or affirm that the testimony will be the truth, the whole truth, and nothing but the truth to help you God? Yes, Your Honor.
All right. And Ms. Beatty, you've gone over the information and discussed that with your attorney, is that correct?
Yes, Your Honor.
All right. And for today's purposes, Mr. Rowe, is she waiving reading of the information?
She is, Your Honor.
Previously, she waived preliminary examination, is that correct?
That's correct, Your Honor.
Ms. Beatty, you're being charged with count 1, controlled substance possession of methamphetamine. That's a felony that carries a maximum penalty of 10 years in prison and or a $15,000 fine. Unless sentenced to more than 1 year in prison, the court shall impose license sanctions. Otherwise, the minimum is discretionary with the court. You understand the charge and the possible penalties?
Yes, Your Honor.
There's one of 3 possible pleas you may make to this charge. You may plead guilty if you are guilty, but don't plead guilty unless you are guilty. You may plead not guilty, or you may stand mute, in which event the court will enter a plea of not guilty for you. You understand the one of 3 possible pleas you may make?
Yes, Your Honor.
Answering to count 1, controlled substance possession of methamphetamine, how do you plead?
I plead guilty, Your Honor.
You understand that no one may make any promises for this court as to what your sentence will be.
Yes, Your Honor.
Court further informs you that if your plea is accepted, you will not have a trial of any kind and therefore give up the following rights. The right to have a trial by jury, the right to have a trial in front of this court sitting without a jury, the right to be presumed innocent until proven guilty, the right to be proven guilty beyond a reasonable doubt, the right to question all witnesses against you, the right to have this court order witnesses on your behalf into court to testify at trial, the right to remain silent and not have that silence used against you during trial, and the right to testify at trial if you wish to do so and have your testimony considered in the same manner as any other person's testimony. Do you understand these rights?
Yes, Your Honor.
You understand by pleading guilty, you give up each and every one of those rights.
Yes, Your Honor.
Mr. Webb, would you put the plea agreement on the record again?
Judge, in exchange for the defendant's plea guilty to count 1, possession of methamphetamine, I'll dismiss count 2 at sentencing and recommend a sentence under section 7411, which is otherwise on.
Mr. Rowe, is that your full and complete understanding of the plea agreement?
It is, Your Honor.
Ms. Beatty, did you hear what was put on the record as the plea agreement?
Yes, Your Honor.
Did you understand it?
Yes, Your Honor.
And are you in agreement with it?
Yes, Your Honor.
Has anybody promised you anything beyond what was stated in the plea agreement to induce you to plead guilty?
No, Your Honor.
Has anybody threatened you or your family in order to induce you to plead guilty?
No, Your Honor.
Has anybody promised you that if you pled guilty, this court will be lenient upon you in any way?
No, Your Honor.
Is it your own personal choice to plead guilty?
Yes, Your Honor.
And are you doing so freely and voluntarily?
Yes, Your Honor.
Do you have any questions about what the court has told you?
I do not, Your Honor.
Have you understood everything that the court has told you?
Yes, Your Honor.
In light of everything that the court has told you, do you still wish to plead guilty?
Yes, Your Honor.
Drawing your attention to on or about March 17th of 2021, were you in Hayes Township, Clare County, Michigan?
Yes, Your Honor.
And did you have in your possession some methamphetamine?
Yes, I did, Your Honor.
And you knew it was methamphetamine?
Correct, Your Honor.
Did you have any license or prescription to have that in your possession?
I did not, Your Honor.
Satisfied with the factual basis, Mr. Webb?
Yes, thank you, Your Honor.
Satisfied with the factual basis, Mr. Rowe?
Yes, Your Honor.
Has the court complied with the court rules, Mr. Webb?
You have, Your Honor.
Has the court complied with the court rules, Mr. Rowe?
It has, Your Honor.
Court has not agreed upon the possible plea or the possible sentence with either the prosecutor, defendant, or anyone acting in the interest of either. Court is convinced the plea is accurate and has been freely, voluntarily, understandably, and knowingly made. Plea is accepted and ordered entered upon the records of this court. Sentencing will be set for October 25th at 10:20 a.m. Defendant is referred to the Department of Corrections for the preparation of a pre-sentence investigation report. Bond is continued. Mr. Wing, any questions for Ms. Beatty?
No,
Beatty,
Your
could
Honor.
you please confirm your address for us, please?
Yep, well, right now I'm at a place in Marquette, a rehab, so it's 241 Wright Street, Marquette, Michigan. and that is 49855.
And a telephone number for you.
Yep, it's, what's the number here? 908, 906 228 7611.
What is the rehab facility's name?
It's Great Lakes Recovery Center.
Thank you.
Yep.
We're going to be sending you some packets in the mail. When you get those, if you could please complete those and then contact the number that's going to be listed there.
Okay, thank you.
Thank you.
Anything further, gentlemen?
No, thank you.
No, Your Honor.
We're in recess.
All right.
Other stuff that we have this afternoon,
I'm sorry, what's that?
do we have anything other than the motion today?
Not for you, we've got a couple civil matters and a couple probation things, but no.
Is defense attorney coming in person, do you know, or?
That I do not know, I don't have it on the screen.
All right. 55th Circuit Court is now in session. The Honorable Roy G. Meek presiding.
You may be seated. In the case of Plea versus Thomas Walsowicz. Counsel identify for the record, please.
Your Honor, Austin R. Rowe making a limited appearance for Mr. Velasquez for purposes of arraignment.
All right. And you are Thomas Allen Walsowicz?
I'm Thomas Allen Walsowicz.
Okay. And you're currently on probation for uttering counterfeit notes, felony that carries a maximum penalty of 5 years in prison. Minimum's discretionary of the court. 2-count violation has been filed against you. Count 1 is violation of Rule 1. Count 2 is violation of Special Condition 2.4. How do you wish to proceed, Mr. Rowe?
Your Honor, Mr. Velasquez pleads not guilty. He asked the court for a court-appointed attorney. Your Honor, he'd like to address bond, and Mr. Velasquez, do you want to waive having a hearing within 10 days without waiving the right to have a contested hearing?
I guess, yes. No, I want the hearing within 10 days.
Okay. And he's demanding this hearing within 10 days,
All right, not guilty plea will be posted on his behalf. It will be appointed Todd Dietrich to represent him. And clerks will find a date for the sentence, for the hearing date. You want it set as a hearing date or as a status conference? You want witnesses there and everybody prepared and go have a hearing?
No.
All right, so it'll be set as a status conference.
Okay.
All right. Anything else? Oh, the bond. Bond is set at $4,300 cash only in defendant's name. You may address it.
Your Honor, at this time, Mr. Velasquez asks the court to amend his bond to a personal recognizance bond. Mr. Velasquez has lived in Clare County for at least 20 years. He has odd jobs, but he tells me that he was to enter 1016 inpatient rehab yesterday. He'd like the opportunity to go to rehab, and that's why he's asking the court for a personal recognizance bond. Furthermore, there's a COVID-19 concern in the Clare County Jail, and Mr. Wilsonovich is presumed innocent until proven guilty by preponderance of the evidence. For those reasons, he's asking the court for a personal recognizance bond.
Court is reviewing the file a little bit. I don't know anything about this case, so. From the Department of Corrections, any opinion as to bond?
Yes, Your Honor, the allegations regarding the probation violations stem from a new felony complaint. It is alleged that he committed a new felony while on probation. We believe bond is appropriately set.
Court's gonna leave bond as is, and Mr. Diedrich can address bond at the next court hearing. You're all set.
All right, thank you.
In the case of the People versus Justin Thomas Lynn Sanders, counsel identify for the record, please.
Your Honor, Austin R. Rowe making limited appearance for Mr. Sanders for purposes of arraignment.
Right. And appears that Mr. Sanders has failed to appear here today. He's not present on Zoom or in the courtroom. Do I see the file? Court's going to cancel and forfeit his bond, issue a bench warrant for his arrest. Okay.
Should I go grab that?
No, that's all right. But we'll set bond at $50,000 cash.
Do you not have evidence of Mr. Angry yet? We got several parties for Tammy Hamilton.
Your Honor, I believe if the case is, if the court's done with Sanders, that's my final case before the court.
I believe it is. Thank you.
Have a good day, Your Honor.
All right.
Okay, all parties have been brought in.
In the case of Tammy Hamilton versus Bradley Martin and Bonnie Martin, and Bonnie and Bradley Martin versus Rodney Dent, Nancy Dent, Lawrence Hovey, Diane Hovey. Counsel identify for the record, please.
Your Honor,
We also have the credit union.
Your Honor, this is Robert Backus. I'm here on behalf of Mr. and Mrs. Hovey.
Your Honor, James Hinks here on behalf of Rodney and Nancy Dent.
Good afternoon, Your Honor. Scott Kramer on behalf of Kelly Rietzel and Big Rapids Realty.
JJ Klaus, Your Honor, with Brad Martin and Bonnie Martin.
That it, everybody? And this was set for a motion to compel, apparently, and a settlement conference. We need to address the motion to compel.
Your Honor, this is Robert Backus. I filed a motion to compel and the issues involved therein have been resolved. There's no need to address them further. Thank you.
All right.
And Your Honor, if I may speak up regarding some housekeeping details.
Okay.
As you know, I was the original defendant and we had filed a third-party complaint since Janie Haroff and Tammy Hamilton's motion was granted, which I was also asking for the same relief, I believe it's appropriate at this time that Brad Martin and Bonnie Martin and myself be dismissed from this case. If the court recalls, we did bifurcate those two issues, and the issues on the front end are now resolved.
Any objection from anybody?
No, Your Honor.
Not from me.
All right, since there's no objection, the court will grant that order. The court will sign an order upon presentation, Mr. Klaus.
Thank you, Your Honor. At that point, I'll excuse myself for this hearing, hopefully save you guys some time.
All right.
Thank you.
Have parties had any settlement talks before this?
Nothing of any significance, Your Honor. We've kind of been a little bit in a two-stage process here with the primary complaint, somewhat taking precedence. And I think we're kind of whittling down now to really the second stage of what this has been contemplated to be, which is a claim by my clients, Mr. and Mrs. Hovey, that they were sold a piece of property that was really subject to a property line dispute, and an encroachment issue that now the court has determined to be a matter of fact that those things did exist. And so now we're in that stage of trying to hopefully embark upon some discovery to identify the evidence that is really more applicable to the back end of this. In some respects, the first part somewhat had to happen first, which is why I think we did the bifurcation concept. But we're now in that part where we gotta get to the rest of the story, and that's kind of where we are now, Your Honor.
Anybody have any thoughts on where we should go from here?
Judge, this is Scott Kramer. I represent the realtors in this case. I do agree with Mr. Backus on this. We've basically been in waiting to some degree. These other claims didn't really have anything directly to do with our clients, but we really needed those resolved before we could efficiently move forward on Mr. Backus's clients' remaining claims. At this point, I'd suggest maybe 90 days of discovery on those remaining claims and kind of move the case forward on its own timeline now.
Anybody else have any thoughts?
Your Honor, this is Robert Backus. I think 90 days is an appropriate amount of time to address what I feel that I would need to address in regard to my claim. And that would be appreciated.
Okay, what the court will do, we'll set this in our status conference in 90 days. And we'll go from there.
Your Honor, one other housekeeping issue. There's still, I guess, in some respects, a party in the form of the credit union. And my understanding is the attorney representing the credit union filed a motion to withdraw. But unless I missed something in the pleadings, I'm not sure there was ever a hearing date set or an order entered. And just in terms of going forward, we've got quite a lengthy caption, and I'm just wondering if it might not make sense to whittle some of the preliminary stuff down in regard to the caption, or would Your Honor prefer just keep as is?
I guess I'd prefer it whittled down, but yes, and I don't believe the court, I'm not sure the court did sign an order to withdraw yet, so I didn't see one that I noticed in the file, but court will have to look.
So in terms of the pleading, my understanding is the primary plaintiff, Tammy Hamilton, represented by Janie Haroff, is that case prevailed on a motion for summary disposition, and they are out and their claims are out.
Correct.
And then my understanding would be further that Mr. and Mrs. Martin filed claims against the Dents, the Hoagies, and the credit union, and effectively those have been resolved and those are out. I don't know that that leaves anything specific with respect to the credit union. I think that would leave us moving forward with the Hoagies claims against Mr. and Mrs. Dent and the Realtors, Ms. Reitzel and Big Rapids Realty.
That would be my understanding also.
Okay.
So if the parties all want to agree to modify the case title from here on out, or just do a stipulation that pleadings will be just titled in a certain way to leave out Hamilton and Martin, but still use the same case number, the court would sign something like that.
Okay. And Your Honor, my thought then is that would essentially leave the credit union as no claim pending against it and no claim pending on its behalf, which would essentially take them out of the equation.
Yes, I believe that would be true.
And so perhaps since it doesn't appear that the attorney for the credit union is out, I'll include her on a stipulation to amend the caption to that effect.
Okay.
Okay, very good, Your Honor, thank you.
All right. Anything else you want to take care of today?
Not for me, Your Honor, thank you.
That covers it from my perspective, Judge.
Nothing for me, Your Honor.
Okay. All right, then we're in recess.
Thank you, Your Honor.
Let's see it over here. All rise. 55th Circuit Court is now in session. The Honorable Roy G. Meek presiding.
You may be seated. Calling the case of People versus Daniel Ellis Anger. Counsel identify for the record, please.
Chair presides, Supreme People.
May it please the court, David B. Carter Jr. on behalf of Mr. Anger.
And you are Daniel Ellis Anger?
Yes, Your Honor.
All right. And this is defendant's motion for discovery. You may proceed, Mr. Carter.
Thank you, Your Honor. I don't have much more to say than that's outlined in my motion in brief. We believe that this information that we're asking the court to turn over is very pertinent to a defense in our case. This is a case in which there's been a delayed reporting. There's also the individual, the complainant in this matter, has waited several years before he had made these allegations. He was in a juvenile facility in which he was in there for his sexual deviant behavior. Prior to my client ever having contact with this individual, he had sexually assaulted another girl a year or two before my client ever met this individual. He had an ongoing issue with his deviant behavior. We believe that his conference with, or his therapy and his juvenile records will disclose that perhaps he had been abused by another person, and that's why there's been a delayed reporting and thus had an opportunity to exaggerate or make false allegations. An expert of mine had reviewed the forensic interview, and he believes that perhaps there might be something in the CPS records that would disclose that. He also indicated that in most of these cases with delayed reporting, CPS and juvenile records will indicate that there's been some type of false allegations in cases similar to this. I believe that this is crucial for my client's defense, and we'd ask at the very minimum that the judge, that Your Honor, review these materials in camera, and if in fact there is some discovery evidence or something pertinent to the defense of my client, that you order the prosecutor to turn these documents over.
Anything else you'd like to say?
No, Your Honor.
Ms. Ambrositis?
Thank you. First and foremost, he speaks of some expert that he met with that tells him all of these things are true and thus these records should be turned over. I don't know who the expert is. I don't know who the expert's credentials are. Have they been recognized in court as an expert witness in these areas? What treatises, what publications are they relying on that say that these things occur that allows this defendant to have access to the victim's personal confidential records, first and foremost. And secondly, he still hasn't met the burden to get those records on your stand away in the companion cases. You can't just make a generalized statement that, well, my expert, unnamed, says that this information could be found there. Well, we don't know that it would be found there. You can't go on a fishing expedition. And in our brief, we note cases where the court even said, you don't get there. So based on all of that, I think the court has to deny the defendant's motion unless he can come up with articulable facts that would point to the ability to breach that confidentiality. Thank you.
Mr. Carter, rebuttal?
Thank you, Your Honor. To say that she doesn't know who my expert is, I've named my expert. We've had a hearing on this issue, whether or not I could have retained indigent funds from my expert. And I've also provided with that motion, my expert's credentials and all that. So I'm sorry, Your Honor, but that's a red herring. Also, the standard is a reasonable probability. And we believe that there is reasonable probability that in fact, these records are going to show that my client, that this individual, I'm sorry, the complainant in this matter is making false allegations. My client denies that he ever sexually assaulted this individual. Again, this individual has juvenile deviant behavior that deals with sexual perpetrating on other individuals. It's common that these people go through therapy and will have their allegations will morph into other things. And I believe that in fact, there are information in there that's going to be crucial to my client's defense, even if it's for impeachment purposes. And I believe that this court has the authority to look through these in camera without us ever having it. And you can make that decision by what you see.
Anything else from either party?
No.
No, thank you, Your Honor.
All right. I think the court's going to take it under advisement and issue an opinion later on this matter. But the problem area for you, Mr. Carter, is the grounded and articulable fact that I haven't seen in your motion. Unless you can point that out to me right now.
I stand by my written motion, Your Honor. It's short. I believe that I've satisfied that requirement.
Okay. All right. We're in recess.
All right. All rise. 55th Circuit Court is now in session. The Honorable Roy G. Meek presiding.
You may be seated. Calling the case of Eric McNeely versus Karen Hollenberger, Richard Haynack, William Simpson, and Dwayne Rogers. Counsel identify for the record, please.
Good afternoon, Your Honor. Thomas DeJurian on behalf of the law firm of Michael Buck Associates representing the defendants.
Kevin Kelly on behalf of the plaintiff.
And Your Honor, just so you're aware, this is Jeff Toyer. We've submitted a notice of appearance as additional counsel for the defendants. I don't know if it's made its way to the clerk's office yet, but we're just observing today.
Okay, all right. No, we got the appearance. All right, we have a motion for summary disposition. You may proceed.
Thank you, Your Honor. Again, we are representing the defendants, Karen Hollenberger, Richard Haynack, William Simpson, and Dwayne Rogers. We have briefed this matter fully, and we hope that the court has had an opportunity to review our pleadings carefully. We have filed this motion because we believe that this matter is frivolous and that the defendants have absolute immunity under the law from such claims as raised by plaintiff. We believe that this immunity is clear and that clearly this case should be dismissed as a matter of law. The plaintiff has not in any way contested the Michigan Supreme Court have granted absolute immunity from tort liability for a judge, a legislature, or the elective or highest appointed executive official of all levels of government if they are acting within the scope of his, her judicial, legislation, or effective executive authority. Clearly, all the defendants in this case, defendant Hollenberger, defendant Haynack, defendant Simpson, they're elected officials, former officials of the Road Commission. They are members or were members of the Board of Commission. And the plaintiff is not contesting that they fall within this category as defined by the statute. Nor is the plaintiff contesting that the Road Commission's manager, Mr. Dwayne Rogers, falls within the category of the individuals identified in the statute, which means that the only matter in dispute is the second prong of the test is in evaluating absolute immunity for tort liability, and that is whether or not the defendants acted within the scope of their judicial, legislative, or executive authority. The action plaintiff is complaining of is his termination. Previously worked for the Road Commission as a foreman and was terminated on June 2nd, 2020. The plaintiff is claiming that the termination somehow is outside the scope of the authority of the four defendants. Again, the manager of the Road Commission can't possibly imagine how anybody could make an argument that the firing of a subordinate is not within the scope of the manager's authority and the scope of his employment. As for the commissioners, again, they're the elected officials that run the Road Commission. The concept that they can't give an opinion or recommend discipline or discharge for an employee the plaintiff claims is outside the scope of their employment. In paragraph 31 of his complaint, he alleges that plaintiff even talking about the concept of disciplining employees is outside the scope of their employment. Those are the terms he uses. Don't know what he means by employment. The test is whether it's action within the judicial, legislative, or executive authority of the defendants. And clearly talking about disciplining an employee is within the scope of an elected board member. The statute, specifically MCL 224.103, authorizes the board to employ employees. Who can fire an employee if it isn't the manager or the board members? This happens every single day. Plaintiff may not like this and claim that it's micromanaging, but board members are entitled to their opinion about the performance and continued employment of all employees at the Road Commission. Is the plaintiff claiming that School board member can't tell the superintendent their preference about the performance of a principal or a teacher, or that this doesn't happen all the time. The fact that all 5 board members discussed this and gave their opinion about disciplining the employees at question or not the ones being investigated is absolutely within the scope of their authority. If they don't have the authority to do this, who does? Plaintiff has given absolutely no legal basis for this claim that somehow the discharge of his client is outside the scope of the authority of the manager of the road commission or the elected officials of the road commission. And instead, in an attempt to avoid this immunity defense, plaintiff has made this creative argument that somehow my clients all conspired to engage in some criminal behavior. I have no clue what he claims by this or what law allegedly he's claiming has been violated. Nobody's made any criminal complaint. This was an investigation into how to dispose of some logs at a work site. The logs are the property of the road commission. The road commission can make any determination it wishes about how to disperse with these logs. We can sell them, give them away. We can burn them. They're our property. Nobody else has claimed them. To claim this as criminal behavior, again, I don't know what crime they're claiming is identified. And to claim that somehow we've done all this to cover this up seems awful illogical to me. As plaintiff alleges in his complaint, this was discussed by all 5 board members and the manager at a public meeting. They decided to pursue disciplinary action against the employees involved. How can you cover this up? This was publicly discussed. Candidly, I have no clue what criminal activity plaintiff's alleging, but it's never been alleged by anybody at any time. And candidly, that claim is without in any way support. This matter should be dismissed clearly. Clearly, this was all action within the scope of the employment. They're also claiming somehow that we have defamed the plaintiff when defendant Rogers, in responding to questions at a public meeting, gave his opinion about plaintiff's performance and allegedly said that he basically had conflicts and was a less than stellar employee and had missed a lot of work and refused to improve after he was told. Now, again, Mr. Rogers has a right to a public opinion about an employee. These statements themselves don't, as a matter of law, arise to any defamatory comments at all. It doesn't call into question plaintiff's morality or his honesty or his fitness for employment somewhere else in any way, shape, or form. And furthermore, again, no hearing was requested by the plaintiff in any way, shape, or form, which would be required in order to claim that he had some due process arguments. Plaintiff was an at-will employee. He has no employment contract. If he claims that his termination was somehow wrong, he should sue his employer, the road commission. He hasn't elected to do this in any way. Instead, he's filed this frivolous complaint against 4 individuals for political and personal reasons. And this matter clearly is without foundation as a matter of law. We respectfully request that this case be dismissed, and we ask for costs and sanctions in having to defend against this matter, which should never have been filed in the first place. Thank you very much, Ron.
Response?
Thank you, Your Honor. I'd first say, there's a question of who owns those logs. So what happened here is that 4 employees, one of which is the husband of a commissioner, one of the defendants, another of the employee is a son-in-law of a commissioner. What they did is they stole government property, brought it to one of the co-workers' homes, who operates a sawmill there. So last time I checked, it was embezzlement to take government property or to misuse government time or to use government equipment and time for personal purposes. That's what they did. And what happened here, and if you look at the article attached to the complaint, in plaintiff's complaint, the county commissioner, or the board, the road commission there and the manager went to pains in public to defend that they didn't do anything, that these 4 employees didn't do anything wrong because we didn't have a policy against it. Well, you know who was saying that they had a policy against it was the plaintiff. And he had reprimanded the employees for taking the logs. And what they needed to do to make sure that there was no suggestion that one of the road commissioner's husbands or relative engaged in criminal behavior, which would certainly have political consequences, if not just being publicly embarrassing, they also had a financial interest in it. They got rid of the plaintiff, who was the only person standing in their way of creating the story, which they have now tried to sell publicly, that there was nothing wrong with what they did, and therefore there was no reason to discipline them. Now, what we claim here is that the defendants, by terminating the plaintiff's employment, engaged in criminal behavior. They were concealing the commission of a crime. They were being accessories after the fact by trying to evade implication in criminal behavior. And it's certainly a use of office to act in such a way, criminal and political fashion, that they are doing it for their own pecuniary interests, not for the counties, not for the commissions, certainly not for the public's interest when they're acting that way. So if you think about delegated powers, right, we're trying to find out, do they have the delegated power, whether it's from the legislature, from the county, their own operating rules to do what they did? Because if they don't have that authority, then it is not protected by immunity. So looking at if you watch the June 3rd, 2020 YouTube video of the board meeting, they're sitting there discussing how none of the board members have the right to get involved with the day-to-day operations. So although brother counsel might try to make a clever argument that they certainly can provide their opinion and whatnot, they all agree they can't make that decision, that that's the manager's decision. So what statute, what provision is giving the individual road commissioners the ability to influence or interfere with the plaintiff's employment? I didn't hear one. The only thing is that they all agreed that the Rogers, the manager, had that authority. Well, you can't have it both ways. Either they had the authority or Rogers did. They don't all have the authority to make that decision. And, you know, I would like to see, where's the vote of the road commission that authorized the termination? There wasn't. So they didn't even purport to terminate him. So the idea that they can give an opinion or try to require the manager to do something, they don't have authority to do that. But even if we got past that and say they do have the authority, they can't do it when it's criminal. The whole theory of delegated powers is that different things enumerate the scope of what they can do, and other things, statutes, charters, ordinances, limit that power. There's no broad-based authority given them to just hire and fire whoever they want. It's limited. It's limited by different statutes, and it's certainly limited by criminal statutes. And so if they are really, you know, if you look at what we allege in the complaint, are they making the argument they have the authority, executive or legislative, to engage in criminal behavior? I don't think they do. And I don't think any professor of local government would say that a local official can violate the law. The second issue that they're raising is defamation. Well, the issue there is, did defendant Rogers defame them? And did he have immunity to do it? Well, what authority does he have to talk negatively about former employees? He wasn't giving the information to another prospective employee or employer, I'm sorry. There wasn't, you know, he wasn't there to ask to go into a closed session. So what purpose do they have with this? Now, I think you can go back to the English common law and find cases that say defaming someone in their profession and employment is defamation per se. It's been the law in Michigan for as long as I can tell in my research. And if you look at the Croton case, they were saying he wasn't being a team player. He was dismissed because of his attitude and inability to work with foreign fellow officers. In this case, Rogers is saying that he had conflicts, he had issues, he needed to get rid of them to move forward. What is the distinguishing features there? I can't find any. I think that's about as analogous of a situation as you can find. That's the court saying that that is defamation per se, and it involved the sheriff, who happens to be the highest elected official in the county when it comes to law enforcement. So to say that that case is completely irrelevant, I think it is disingenuous. The other argument they make about criticism, well, if you read the two cases they cite, there's no allegation of any false comment. They're just saying, you know, hey, I didn't like what you did. This is why I didn't like it. There's no allegation of falsity. And that's how you distinguish, you know, criticism, which is an opinion based on true facts, true events that happened, and defamation. Because in defamation, it's something that didn't happen. And that's exactly what Rogers did when he said that the plaintiff had issues, had conflicts, had the opportunity to improve, but he didn't, and all the other things he said. The last issue, as far as this, the name clearing hearing, well, Defendant Rogers, he's an official. He's not the board. He doesn't call public meetings. What authority does he have to give Mr. McNeely a public name clearing hearing? He doesn't have one. So he gets to then, you know, defame and stigmatize my client with impunity because he can't, or impunity because he doesn't have a public meetings. I mean, that's, I think, a situation that is distinguishable from the cases cited by the defendant. I would just reiterate that the plaintiff called out this situation. He reprimanded the individuals. The individuals were related to two of the defendants, and they conspired to conceal that crime. If you have any other questions, I'd be happy to answer. Otherwise, I'd rely further on my brief.
Rebuttal argument?
Briefly, Your Honor. First, I think the Quinn case, the Supreme Court's pretty clear when it lays it out and says, in regards to showing a liberty interest, it says the second test is plaintiff is not deprived of his liberty interest when the employer has alleged merely improper or inadequate performance, incompetence, neglect of duty, or malfeasance. The comments allegedly made by Mr. Rogers in response to a question at a public meeting in no way arise to anything near that standard. To claim that somebody had conflicts and missed a lot of work and didn't respond to previous attempts to improve performance doesn't even come close to that standard as a matter of law. As for this, again, criminal activity that Mr. Kelly keeps referring to, I don't know what crime he's talking about. Nobody's been charged with a crime. Nobody invested in any crime. The logs are the property of the road commission. Again, so he's claiming that the road commission, someone's embezzling from the road commission, and the victim of the crime is now conspiring to cover this up somehow. And he's attacking the victim of the crime. There is no crime here. There never was a crime here. There was a determination and an investigation into whether or not road commission policies were followed or not. But to claim criminal behavior candidly is, I think, pretty aggressive and beyond the scope of any proper allegations.
Your Honor, can I just add something there? It might be interesting to know who conducted that investigation for the road commission.
Your Honor, finally, I'll point out that the law is quite clear, as we put in our brief. Plaintiffs keeps arguing about my client's motives and their nefarious reasons for their behavior. All that's irrelevant. The court has clearly said that they're not going to look into motive to determine whether or not immunity applies. That's not a factor at all. I mean, we strongly have cited the case law that clearly says that the court is not going to look into the motives of the actions of the players. That's completely irrelevant to a determination. So whether my clients were totally altruistic in their behavior or nefarious is irrelevant to this legal determination.
Anything else from either party?
Nothing, Your Honor.
No, sir.
All right, court's gonna take it under advisement and issue an opinion later.
Thank you, Your Honor.
Thank you.
We're in recess.
All rise.